and welcome to The Grey Area, the podcast where we talk about things that's not always black and white. And today we have two important guests with us that are going to actually share their take on a recent judgment, an appeal judgment that was handed down recently in the appeal court, where they were in the midst and the thick of things. Joining us today, we have Mtho, Maphumulo, and JP Rudd, both of whom are partners at Adams & Adams. They specialize in insurance litigation and dispute resolution and advise clients and insurers on all aspects of the law and insurance-related things. They also have a very popular publication out there where they are constantly educating the public about the latest updates and things happening in the insurance world. So guys, thank you so much for joining us. It's good to have you both here.
Thank you for having us.
Thank you.
Thank
Thanks
you.
for having us.
I think before we get into the nitty-gritty, just tell us, how does it feel to be winners?
We're very relieved because there was a lot riding on it, so relief is one of the bigger things.
Yeah. No, I couldn't say it better than JP. I mean,
Just relief.
It's a huge relief.
Yes. You weren't walking through the court like bad boys.
Okay, so let's get into the context of what exactly was the case. I think it's always good for the benefit of everybody watching this to get an understanding of what the case was about. Why was it so important? So I'm gonna put you guys on the hot spot and the hot seat. So JP, Mtho, do you want to take us through what was the case that we're going to be talking about today?
Thanks, Nadia. Without really getting into the technicalities, because I don't think this show is worth going into those details necessarily, but just in brief and just on the face of it, the matter pertained to a board notice that was implemented by the RAF and the Minister of Transport. And so when you lodge an RAF claim, there is an RAF 1 form that is prescribed in terms of the Act that you need to comply with, and you fill in all the details, provide all the documents necessary. This form stems from the 2008 legislation, which it just requires substantial compliance. Sorry. But now, 2021, 2022, the RAF then came up with a new board notice which had additional onerous requirements for the lodgement of claims. And those additional documents obviously then burdened the potential claimants and basically, in effect, blocked the claimants from being able to lodge the claims. That's really the gist of the matter.
I agree, and just to add on, obviously, in a matter like this of this magnitude, there's a whole lot of stakeholders involved. So from your claimants who are unrepresented, so many claimants in South Africa don't have the luxury of representation, and then your hundreds of attorneys out there that do RAF work. And then, obviously, from our side, we come in on it. We were acting for the LPIIF, which is, I always struggle with the full name, but it's Legal Practitioners Indemnity Insurance Fund or Insurance Indemnity Fund. And where it's relevant for them is they are the insurer for all attorneys, and obviously you've got your top-up insurers as well, where it does become very relevant and very real, because the requirements were raised substantially, so much so that it almost became impossible to comply with. And as a result, as you can imagine, then it becomes a prescription issue, and then it becomes a liability issue. But we'll talk more to that.
Yeah, so I'm just like, now that you mentioned there were these onerous requirements, can you give us just like a breakdown of what these requirements were, or a very practical example, in a scenario where someone's lodging a claim, what would be required?
I'll speak to the rationality of it, because they came out with a fixed list of, I don't know how many requirements it was, but it was close to 60 odd, if I'm not mistaken.
Okay.
And where they lost sight of rationality was that they applied it across the board. And as you can imagine, claimants, there's no claimant alike in South Africa. Yes, there are similarities, but what they would do, and it's clearly, you know, you don't have to be a specialist in admin law or law in general to know that if you lodge in a claim for, say, a minor, and the fund would want salary advice slips, tax returns, and if you can't submit stuff like that, which are totally inapplicable to a minor, they would reject the claim because they had this prescribed list, and if you didn't comply with every, so it was a tick box exercise. Did you comply with every single requirement on that list? If not, they would reject the claim.
So there were very onerous requirements in terms of what you needed to submit for your claim to be accepted.
Registered,
get through the first registration block.
Yes.
So then you mentioned that your client was the LPIIF, who is the insurer for all attorneys, the primary insurer for all attorneys in South Africa, and then they flagged that as a risk for attorneys because the claim would ultimately prescribe in their hands if they could not get all the if they could not tick all the boxes.
Absolutely.
So I know I'm jumping the gun here, but I think for me, from an insurance mindset, what turns in your mind to say, as an insurer, this is going to have an impact across the entire industry? I need to get involved at this stage. You know, I don't think it happens often where an insurer would take a stance or a strategic stance like this to say, I need to get this matter resolved first, otherwise I'm going to have millions of problems in the future. So I'm sure you were involved in those discussions with your client.
Yes.
Could you take us through, I mean, what are the red flags? I mean, we have lots of experience in red flags, right? So as an insurance company, what was a red flag that said, ding, 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 we need to get involved here?
I think I'll leave this to Mtho to speak to just the magnitude for the LPIIF.
No, I think what it comes down to, Kamini, it's the risk management from the insurer's perspective. Knowing that you've got this exposure if this thing is not resolved or arrested at that stage already. So what the insurer, which I mean, credit to the LPIIF for taking such a proactive approach to the matter, because what you would, if you do not take that stance, what then you sit with is that uncertainty as to what is going to come in the next 5, 10, 15 years. There's no certainty in terms of the law, in terms of your exposure. And just to give you an example, specifically in this matter, so between 2021 and now to the date of the judgment, there had been millions of claims that had been submitted and rejected by the fund on the basis that they did not comply with the requirements. And the exposure was already sitting at 1 billion plus range.
Sure.
So imagine now sitting with that, without you as the insurer, a responsible insurer, taking any initiatives to try and get certainty around that. You then sit with a situation where you, in this perennial state of uncertainty. And from the risk management perspective, you would know better, having been in the insurance space forever, as to in terms of the funding, in terms of the seeing the future. Then it goes to the top-up insurers, as JP has said. It just creates that, eternal uncertainty. So I think that I would just say it was more about the risk management. Maybe JP can add.
And to add on to that, your LPIIF is a bit unique in the sense that it's not like your normal insurer. I'm going to refer to them as a statutory insurer, and their premiums are not premiums like private insurers would be able to procure. So they're dependent upon a levy from the Fidelity Fund. I'm not sure of the internal workings how it works, but the point is that they're not a private insurer and they don't have endless funds. And for them, it was a situation where, well, either we get involved in this or we stand to go belly up.
Yeah.
Because just the magnitude of the claims. I mean, Mr. Arban, the general manager, told us it was a billion plus, as Mtho had said. And I don't think they had those funds in reserve to cover something like this.
So JP, you've brought in the Legal Practitioners Insurance Indemnity Fund. It is actually a mouthful to say it out loud, right?
It is, absolutely.
And to be honest, a lot of attorneys don't know that they have that cover,
yes.
Right? Now, if I had to think about it from an insurance point of view, when I think of that, the LPIIF, I know it's a cap limit, but if you think of the various limits, it's not enough to sustain the entire volume, and plus there would obviously be costs attaching to those matters for the LPIIF. But if you think about it on the top-up level, there's a greater exposure for top-up insurers because of the volumes of matters and the higher limits that will be offered. So therefore, it's so important for insurers to be involved in matters like this or be aware of what's actually going on and the greater impact that it will have. So, you know, when I think of these matters, I also think of like the social justice aspect. And you've touched on nicely on that. I mean, I think it would be great if we could break it down more to that aspect of the impact that it would have on those victims that are, well, have a right to claim, but now their claims are either being denied or delayed.
And spot on. I mean, that's the important thing when it comes to the road accident fund. If you think of it, South Africa's road accident fund is different to models around the world where you have your private insurance, and in a private insurance scenario, something like this wouldn't feature. But now you've got a statutory insurer, because that's actually what the road accident fund is. It's a statutory insurer, but it's there from a social perspective. It's there to compensate victims that cannot afford insurance. Now you're sitting with a situation where the fund itself, who's there and supposed to be there to compensate them, goes and raises the requirements to such an extent where your man on the street simply cannot comply with the requirements. And if you think of it as well, that they had certain requirements pertaining to medical legal reports. Now, your medical legal reports in a matter like this can amount to 100,000, 150,000 rand.
Sure.
And it was front loaded in the sense that the fund required people to have it up front and lodge everything at once. And if you don't have it, you're out. So most of the people in South Africa would not be able to do that. And you've got to distinguish between your represented and your unrepresented clients. Obviously, any unrepresented client is even worse. But even the attorneys that are representing claimants, they are also not in a position to comply with that. And that goes back to the insurance side of it, where you just simply stand to not comply. And if you can't comply in that 3-year period that you have to lodge the claims, the claim prescribes and you then become liable, because, you know, if you think of it from a liability perspective, they, from an attorney or from an insurer's side, they're going to say, well, you took the claim on knowing the requirements. And if you do, you can't complain about the requirements, because the law is the law until it's set aside. And unfortunately, it has now been set aside, and it reverts back to the old system, where I think, Mtho, maybe you can explain just the substantial compliance component versus what has now been set aside.
JP, maybe before I get to that, and my response here is going to tie in with Kaminya's earlier question about, pertaining to the risk management. And what you've just touched on, Nadia, about the legislation being a social legislation and all that, and there to serve the victim. So for the top-up insurer to pay, they would have needed the LPIIF to pay first. So what that means is, if you do not take proactive steps, it means you may sit with the situation where the LPIIF does not have enough funds and they cannot pay out. That would then mean the top-up insurer will not pay out. and that means that the claimant, they've got no recourse at all.
Yeah.
So that I think it's quite important to take note of. But then maybe going back to JP's point about substantial requirements. So in terms of the Act, what you then require, my understanding is you would need the statutory medical report, which is basically the doctor that treated you as the victim of the road accident. As the road accident victim. So you would need to get that report from the doctor. You will need your accident report as well from the police station, and you fill in the form, and the rest of the documents like the medical reports, those can come later on, which is I think is that's just to get your claim lodged and registered on the system. It doesn't mean you will succeed with your claim, because they still have to be in the investigations by the RAF and also from the claimant's perspective. And in terms of, I think JP has very nicely explained what the requirements, for an example, in terms of this new, now invalidated board notice, but they were just ridiculous. And the feedback that we've also received from some of the practitioners is they would try by all means to comply with all those requirements. In some instances where it was possible, they did provide all the documents, but they were still not validated, because they would write back to you and say the ID copy is missing, yet it was part of the documents. So it was just a very chaotic situation from that perspective.
Yeah. So you're taking me back a bit, because I did my articles that are RAF plaintiff's attorney. So when you're talking about accident form and the lodgement documents. So when you lodge the documents with the RAF, I understand that then prescription is interrupted.
Yes.
Yeah.
Right. So because of these new requirements, prescription will just keep running in the absence of the lodgement, and that's the crux of it, right?
Yes. Yeah.
Okay. So then you've got this case now. You want to fight it. What happened next? Take us through what happened in court.
Yeah.
So it was a journey, because it started, remind me, 2022. Yes.
Okay.
Yeah. So it's
4 years later.
Most court cases, it takes long, and it started in the Pretoria High Court.
Yeah.
And it was in front of a full bench in Pretoria, just because of the significance of the matter.
Just one remark on that, and that was JP's idea, which was brilliant, because you instead of going to the High Court before a single judge, you from the onset request to be before full bench, which was incredible.
It's just the reason for that is that where you do anticipate the appeal process, it just expedites it, in the sense that, because if you if you don't have a full bench, then and you're in front of a single judge, then you can go first to a full bench and then you go to the SCA. So we did it we were minded by, both parties are likely to appeal, whether it's our client or the RAF. And so the quicker we get to the SCA or the Concord, the better. And as such, we wrote to the DJP at the time, which I think was Justice Letwaba, if I'm not mistaken.
That's correct, yeah.
And we had meetings with him, and he agreed, given the significance, a full bench should be constituted. And from there, we were driving the process, as any review is done in terms of admin law. And what then also happened is we saw that a number of other claimants intervened as well in the review application. So because obviously it wasn't only significant for our client, but individual law firms and individual claimants, they expressed the interest in
and medical
litigation.
practitioners.
Yes. And so we had like ambulance services that intervened. because they all had interest in it, and those intervention applications were first heard and granted, and so they became co-applicants with the LPIIF as the main applicant, and eventually we got to the full bench, and we were. Was it a day or two that the matter was argued?
It went for 2 days before the full bench,
Yes, and fortunately the full bench found in our...
and that courtroom was so packed. I remember it was packed.
Yes.
So there was legal practitioners, there was advocates, there was experts, because if you think of the whole stakeholder supply chain,
the ecosystem,
it really affected everyone.
Everybody.
And so the matter had a lot of interest. I mean, there was not, a week that went by that Mtho and I wouldn't receive a telephone call from a practitioner or from an expert or from a counsel, just asking, what is the progress in the matter, what and also, what do you anticipate is going to happen, which is always difficult because obviously you're hopeful it's going to go in your way, but they just sought that reassurance from us, which was difficult to provide.
You wanted reassurance from somebody else.
Yes. But once we got the full bench judgment, that did. It's always better going to the SCA as a respondent, as a appellant, and but there was also a lot of intricacies involved in it because the following the judgment and the leave to appeal stage, the fund had abandoned certain of the relief at that stage, only to later reignite it, and so it complicated the leave with the SCA, but at the end of the day, I think the SCA were minded by the significance of the matter and gave them leave, which was then heard earlier this year in Feb, and the judgment came out just a few weeks back.
And I mean, well done to you guys for actually pushing this through, because like you said, Mtho, you summed it up nicely. It was like an ecosystem and a network.
Yes.
JP, you said a network that was impacted. So it wasn't just the victims, it was so many other parties that were impacted. And you can almost see like the LPIIF, kudos to them for trying to look after the professionals as well, for also trying to look after insurers' interests as well, but also the general public. And I think that's such a big thing, because very often people are very hesitant to actually take on someone in that public sector.
Yes.
And this example, I think, it's a good example of how insurance is changing. Before it used to just be by the letter, by the law, and now we take into account those social justice factors. We take into account how is it going to impact everybody across the board, and proactive risk management is a perfect example of it, because whereas you could have just let everything fall apart, you have to think ahead.
Yes.
But I mean, I'm just listening to you guys talk about it. I just think to myself, you must feel like
so legends, man.
We actually had a conversation. The last conversation we had was with the president of the IIG, Insurance Institute of Gauteng, and we were talking about what everybody asked. How did you get into insurance? And everybody's generic answer is, I just fell into it. But the question now is, what keeps you in insurance? And when you guys talk about this, and not just insurance, about law. So, I mean, we had many conversations recently about law, but this is the sexiest one I've had so far. And you think to yourself, this is what keeps you in insurance. This is what keeps you in law, because there's so many questions out there that need to be answered and that need to be reshaped according to what's going on in the world right now.
Absolutely.
Yeah, and I think, you know what, you said proactive risk management, right? I would like to term it as proactive risk activism, because I see this case as being you guys being activists.
It's activism,
doing something for the greater good of the public, because I think of it with insurers, right? If I just put my insurance cap, I mean, a lot of the claims would be as a result of the prescription cases, right? So now you know you're going to have a lot more of these cases, but something has been done to say, hey, we're trying to help people, but also help everybody in this ecosystem that will be adversely affected. So I think it's well done to you guys for...
Thank you.
Like I said, people often back down when they think, okay, as a public entity that we're going to be challenging. It's like, we don't want to get our hands in this, but I mean... kudos to people like you that are willing to fight the fight for the greater cause of mankind. We love that. You know?
Well, one thing we didn't touch on is that it actually served before Parliament as well.
Yeah.
Oh, really?
Yes.
It's you know, Mtho and I have spoken about it many times. It's very few times in your career you'll have a matter like this, just in terms of significance, quantum, but you know, how many people it affects as well, and also where an active litigation matter actually serves in front of Parliament before it's heard, and that was special because we had again Mr. Harban who had to go testify in Parliament, and I think he did it very well. He really Thomas has got a skill of being able to relate to so many people, and
it's personable.
You know, when we saw him in Parliament, it's like he took a duck to water, and it's like he's been there before, and he wasn't. And even that itself took a lot of prep from our side because Parliament's legal advisors reached out, and there's an affidavit that you have to prepare in advance of such an inquiry, and it really it's other element to it which you don't really see in normal litigation, and it's quite scary because you know it gets televised. And it's there for everyone to see, and so this matter's really come full circle in terms of where it's been.
You guys can be very proud of yourselves. Like I said, it takes a lot to get involved in something like this, and I think it also sets the tone for example, other interested parties, for example, insurers, as to when they should be getting involved in things like this. And you know,
to me, it's shocking that top-up insurers were not involved. At least paying the cost. Or maybe, you know, there's other elements that go into it.
I think they most probably saw the LPIIF involved, and I would imagine the LPIIF was keeping them updated, and they were, you know, there was a lot of confidence in that.
Of course,
but I agree with you because obviously, you know, they had a lot riding on it as well, and just your normal attorneys as well. If there's not enough insurance, you know, your attorneys become liable themselves. And you know, attorneys would have been sequestrated. I mean, the consequences are just dire from a professional perspective, but also just again, you know, from a social perspective, your clients that are there who are contributing to the fuel levy, and just on that note, it's something that actually reminded me of the other day, is that just how things work in South Africa. If you think of people who are riding taxis every day and are expending 40-50% of their salary on transport. Now those are people that are supposed to be covered in terms of this legislation, only to be left behind. Meanwhile, they're contributing 50% of their salary to, yes, it's, you know, not all of it goes to the RAF, but a large component of the fuel levy does go to the RAF. And to leave people like this aside with no compensation, no recourse in terms of the common law wrongdoer, it's just, you know, it's completely unfair. And yes.
I think it also just doesn't align with our constitutional principles, right? Access to justice and fairness, and where's that balance? Because, okay, the one thing we have to admit, we do have this major socioeconomic disparity in our country. And when you impose something like this, you further aggravate that situation.
But what were the arguments from the RAF? Because for them to take it all the way to the SCA, they must have had some. What were they? In my mind, I'm imagining what they said, but what were the actual arguments?
I think it does get a bit technical because what they were going on. So there's a bit of history in this because there have been at least 2 board notices. So, but maybe just focusing on this one specifically, maybe, I don't think we can discuss the second one without touching on the first one. So on the first one, what they had done is it was challenged on the procedure to say the fund does not have powers to prescribe and implement their own requirements. Okay, so that's one of the matters we also took to review, and we onto the review process, and we came right on that one. Then what they did when we interdicted them on that board notice, they brought this new board notice now, but it was now through the Minister of Transport.
Yeah.
So their argument was to say the minister does have powers, and the minister had exercised his powers in accordance with the lawful administrative action processes. But that was their main point. And they now, that's now the procedural part of it, to say it must stand because all the processes were done in accordance with the letters of the law. On the substantive part of it, they really did not have much to say regarding that. But I mean, they did make some arguments to say, well, the rationale behind this is to say the fund is currently not in a position financially now to absorb all these claims, etc. And these requirements are necessary to ensure that all claims, when they are submitted, well, they do place the fund in a position to immediately assess, evaluate, and either reject or accept and settle claims. So that was their biggest thing, to say the requirements are as broad as they are because they are meant to facilitate or to achieve quick resolution of matters, instead of just a very superficial documentation and information, which will inevitably lead to litigation because of the time constraints. So that was, in a nutshell, what they were going on about.
And both of you are in the claim space, and a person must remember that the fund is an insurer. Yes, it's a statutory insurer, but it's an insurer. So if you receive a claim, you don't receive everything at once. You've got an investigation obligation, and as such, the fund has also got an investigative obligation. And that they forgot. They wanted to front load the claims.
That's the right.
And you need to give everything up front, and they don't need to investigate at all. And the Act, by the way, gives them large investigative power to call for many things. But you know, it doesn't have to be done up front. And they were complaining that claims were being submitted with the bare minimum documentation, making it very difficult for them to assess, but again, they lose sight of their investigative powers. And just like any insurer that investigates claims, I mean, there's no policyholder or insured that gives you everything up front. They would give you, you'd get your claim form and you'd get a few other documents, but very seldom you get everything up front. And then it's up to you to investigate the claim, call for more information, find out people, you know, that normal investigative process behind the scenes.
This is an example of skills gap in the insurance industry.
And what I thought about JP as I was in the reading of the judgment now is what the fund actually lost sight of is the claims are not the same. The claims are not the same. Some will have very contentious merits. What purpose does it then serve to involve all the experts, get the reports, only for the claim to have no merit? By that time, the claimant, if they were in a position to pay for those medical reports, how are they going to recover any sort of cost? They've incurred at least 20,000 in quantifying, only for the claim to be rejected. Then what?
But also, if you link it back to how we deal with claims in the insurance space, you'd still call for more information because, like you said, no matter is the same, and you're still going to have to go back to the party to be fair in terms of that investigative process to ensure that you have a fair outcome.
Absolutely.
I mean, at the end of the day, it is about fairness. It's easy to say reject because you want those, or deny because you want those liabilities off your books. But in the long run, it is always something that comes back to bite you if you don't do your proper checks. So hats off, you guys are my heroes here. I love these social justice matters.
No, and what's nice is we've been told by a number of firms that the fund have accepted the judgment. So
So
that's
you're not
nice.
going further.
We a bit heartsore on the one side, but happy on the other, because at the end of the day, we wanted an outcome that was accepted, and as such, you know, it's been implemented. People are able to lodge again in terms of the act, and there is no further appeal.
That's good. Congratulations.
Thank you.
Well done.
But you guys are legal giants now, so you'll be at the Concord sooner or later.
We'll be
I have a few pending matters, but
yeah.
But thank you for this. I think it's so important that we, you know, share why these matters are so important and the implications of these matters, because they do have broader implications.
yes,
We have to shine a light on these matters that that really benefit the whole country. I mean, there's a lot of people like you guys that are working behind the scenes, and Thomas, that are working behind the scenes to make sure that people's rights are protected. And you know, sometimes we work with a lot of people that only, you know, are protecting the pocket. So it's good to we that's why we started the gray area, to shine a light on these type of
That's a very good point, because I think we've had a chat about it before. I mean, you always get the perception that the big firms only really care about making money from everything. But if you take this case, for example, and it's not just one isolated case, there are many other cases which really serve a broader public interest. So absolutely, I do agree with you on that.
Well done, guys, and thank you.
Thanks,
Thanks for being on the gray area. We hope to chat to you guys again the next time you have a case like this.
thank you. Thanks for having us.
No, thanks, guys.
It's
Appreciate
been great,
this.
man. So we're going to do a bit of a rapid fire, because we'd like the public to get to know more about you guys. So we put you on the spot. So you say the first thing that comes to your mind, right?
Okay.
Insurers rejecting a claim.
I always think about what the defense is to such a claim. So just out of you know, when instruction comes your way, the first thing you do is, are you going to defend the matter? Obviously, if there's no defense, you advise your insurer that there is no defense. But it's there hasn't been a claim that's come that I haven't thought first, you know, what is the angle we're going to take? And there's a lot of beauty in that, because there are so many defenses in law that a person can take. And Mtho and I love that, because, you know, there's just so many defenses that there are. But again, I'll stress, if there is no defense, we very quickly advise the insurer that they should settle. And yes.
Okay.
So we always ask this controversial question, right? Do you guys believe that there should be pineapple on a pizza?
Personally, no. but I do accept that people have got different choices. But for me, no.
Okay. So I hear this argument from my kids who are arguing about it ever so often, and I'm wondering.
It's an important question.
It's a bit of deja vu.
So if you guys weren't in practice, what would you be doing?
Sure, I would have had a beach bar and been far away from anything corporate.
I would have been in sport, for sure.
Soccer. Up the bucks, right?
That, if not Barcelona. Probably Barcelona, but then Paris would be the second best choice.
Okay. And what's the first thing that comes to your mind when you think of Nadia and Kamini?
Brilliance. Brilliance.
And just how good you are together. You can obviously see you two have been friends for a very long time, and your energy is just next level.
Oh, thanks, my fans.
What are you reading right now?
Judgments and new claims. So I don't have time for any books and stuff like that.
That's the best answer.
It's a very honest answer.
And what about you, Mtho?
Well, mainly the rules of court, but I've recently bought a book. I think the title is Locked In or something like that. It was recommended by our partner. Gregor. Yeah.
Okay.
So that's
And what are you listening to? Don't say judgments on audio.
Well,
Shoot that judgment.
so we do listen to there is a podcast Spartan that does
yes.
Cheating on us.
so we listen to those as well.
Yes, those are very good. Yeah.
And it just saves time in the sense
Yeah.
that it saves reading time in the sense that Mtho and I think we both do it when driving in. You just put the podcast on and it deals with, I think, 5 cases, if I'm not mistaken, and it's a podcast that, a service, put it that way, that summarizes judgments, and it's helpful for legal practitioners because,
that's awesome. Yeah.
As you both know, a judgment can be very long, and very
yeah.
difficult to read,
Mhm.
and it's things like this in your podcast that shine light on things that make that you wouldn't know about necessarily.
Mtho?
Yeah, no, same. It's the podcast by Louis. And to be honest, JP and I think at this point in time, we really have no time to do anything else. That's the reality of
Don't
it.
say this. People are watching.
but that's it. I mean, we do take moments
time
to
in the week.
Time in the week, no, for sure.
Well, you do work on weekends,
Yes.
but you do it remotely, and I try and do it. I work around the family, so I've got kids like 12, 13. Obviously, they don't wake up early, so I try and do things before they get up.
Wake up.
Yeah.
Yeah.
And then on the weekend, you've got a lot of time. Mtho likes to socialize. So.
Yeah.
So much
Oh,
fun.
shit.
Thanks again, guys, for joining us.
Thanks for having us.
Thank you.
And we are so excited to see what else you'll be involved in. And I think
Yes.
for everybody out there, like we mentioned earlier, JP and Mtho do some amazing write-ups, which are so valuable if you're in this industry, within the insurance and legal space. So check them out.
If you want to lay contact details, Adam and Adam's website,
Yes.
That's correct.
or contact us and we will pass it on.
We'll look you up. Yeah. So until next time, bye.
Cheers. Bye.